Yeah, hopefully I'll click on the got it button and not the leave the meeting.
Okay. Well, I'm going to turn this over to Judge Wilson to start. He's going to present to you today on the new Indiana Child Support Guidelines. And I forgot to clarify, they do start January 1st. Is that correct?
January 1,
Okay, good.
12
I'm going to mute
o'clock
everybody
midnight.
other than the judge. So feel free to ask questions either in the chat, and I will try to keep track of that.
Okay. Give me one moment. I'm trying to get rid of an annoying thing on my window. I'll just wing it. Anyway, let's talk about this thing, the brand spanking new Indiana Child Support Guidelines. I'll mention that I put together this rather lengthy document. What I put together myself is only about 8 or 9 pages, but I attached all the other stuff, like the new guidelines and redlined version and tables and all of that. George Catanzari had sent that link around to the family law group so that you can download it. It's like 27 megabytes, so it's too big to email. That's sort of the quick guide of here are the things you need to know and the things that you'll have to use until the state puts together the the printed versions of things online and the like. And I looked this morning, I still haven't seen them put up any new ones. Regardless, let's talk a little bit about, why does this thing even happen? And before I was asked to serve by the Supreme Court on the Domestic Relations Committee, which actually sounds more impressive than it is. They just sort of send you an email and say, "Hey, would you serve on this?" Because you said you'd be interested. I really didn't know much about the revision process. I just know that every so often it seemed we would get new child support guidelines. Well, it turns out that this stuff is done because the federal law requires it. It all goes back to 1988. You've got the Family Support Act that says the states have to put together child support guidelines and things, and then there's part of the Code of Federal Regulations, those good old CFRs that we tried to forget about, that requires a 4-year review and potential revision. And if anybody's desperate enough for the actual CFR site, let me know. So the Domestic Relations Committee that I referred to is made up of, I don't know, 15 or so judges and magistrates from around the state. It's liaison to the Indiana Office of Court Services. There are a couple of staff attorneys that we work with. And we began this process almost 2 years ago. It actually started in February and March of 2022, where we knew this was coming up. And so it got started. We just had some very vague general discussions, what we thought the process should be. And we hired an expert who has played that role before. His name is Dr. David Betson. He's a professor emeritus of economics and public policy at Notre Dame. And he was a very amazingly good resource. Let me just sort of walk you through this lengthy process. And before I continue, is anyone else seeing the little window I have that says this meeting is being recorded? No, you're seeing the slides. Okay, perfect. we hired Dr. Benson back in the first part of 2022, and then we really began to do the work in July of 2022. And that process started by looking at the various economic models that claim to determine the cost of children. We made sure to get our checklist of what all we had to do to make sure that the federal government was satisfied. We, with the process of our review, in August, we were able to identify areas that we thought where revisions were necessary, both from a numbers economic standpoint as well as from an experience standpoint. To the extent possible, we tried to ask around to other judges and lawyers, just, hey, is there anything that you can think of in the guidelines that ought to be fixed? And we got some things there. So then in August of 22 through May of 2023, committee members were assigned different sections of the guidelines to either revise or to draft. And then we would review them as a group, select what we thought was the best language, and things. It was, really quite processed, and part of this all had to do with these economic models, which meant that we got to, thanks to Dr. Betson, we got to see a lot of graphs like this, and this, and this, none of which made sense to me because I am not an economist by any stretch of the imagination. But, there is a whole lot of stuff that goes into this. And we continued on in June of this year. We opened up, or we published our completed revisions and invited public comment. We received, I think it was 176 comments from people off of the committee, not on the committee. Probably 80% of them were from citizens of one form or another who either wanted to know why we weren't doing our jobs and making people pay their child support, or they were from people who were saying, why do people, why am I required, or why is my son required to pay child support? Those we could very easily and quickly set aside. But, the public did identify some things that we thought needed to be changed, especially in commentary to the guidelines. And so in mid-August, we gave the revised guidelines to the Indiana Supreme Court. And then they did not formally approve them at that point, but they did not. What we were hoping is that they would say, okay, we don't have any problems with what we see here. Mid-September, they were formally submitted to the board of directors of the Judicial Conference of Indiana. I had no idea that even existed. And we submitted them again to the Indiana Supreme Court formally. Everybody signed off, and on October 17, 2024, Indiana Supreme Court entered an order saying that they were approved and would become effective on January 1. Of course, I don't know any courts that'll be operating on January 1, but if, it'll, in theory, that's when we get started. So let's talk about some of the highlights. What have we done here? Well, we have new weekly support schedules based upon the economic data that we've been presented, and the analyses of that data. We have revised the low income adjustments, which used to be based upon just one parent's income. Now we've taken both parents' incomes into consideration. We've established a process for the occasional issue where you have a parent spending a different number of overnights with different children. We've got a formula for that. We obviously we had to update the child support worksheet. We've clarified and emphasized some things that I'll talk about. Updated some verbiage about the assessment of certain expenses in paternity cases. That was in reaction to a law that went into effect as passed by the legislature. But most importantly, probably the thing that will bring a smile to everyone's face and that will make everyone's life easier is we have eliminated the 6% rule for payment of uninsured healthcare expenses. And we have put together a process in the guidelines for how we allocate those and how we accomplish the task of reimbursement. And you'll have to forgive me, I've got some notes here that I'm working off of. So how did all this started? Well, our first set of schedules ended up in 1989. And what's kind of odd is that I didn't know this, but the data that we're using on is based on a consumer expenditure survey from 1972 and 1973. There's some of us on the call here who are old enough to remember that, that those were the days of, Richard Nixon and Gerald Ford. And there's been a lot of analysis of these things. Do we look at spending on food versus spending on the family as a whole? What's the right tool to use? And there have been changes over the years. In 2010, we they created a low income adjustment for weekly incomes between $100 and $290 that we're supposed to take into consideration basic subsistence needs. We're dealing with that. And then, it turns out that some of those slides I showed you before that had the different lines, well, some of them talked about, using this methodology, like I have to look back, there's the Engel method, no relation to Marx and Engels, but the Engel method of looking at family spending and, what that means versus this other guy, Rothbarth, who looks at a bit broader type of data. And all I can say is thank goodness for Dr. Betson, because I think everyone on the committee felt that this stuff was way outside of our scope of expertise. And Dr. Betson was able to say, okay, here's how the Engels method works and what people like and don't like about it in the economics field. Here's how the Rothbarth method works and why people like it or don't like it, and sort of helped us say, okay, this appears to be the best methodology. And so what we have now is we're using data from the consumer expenditure surveys conducted in 2013 and 2019. And according to my notes, this was based upon a comparison of the total amount of spending that adults with children spend on themselves compared to the total amount that people spend on themselves if they don't have children. And the assessment in the field of economics and public policy is that this provides good data and a more accurate analysis. So one of the things that this led us to that will affect some of the cases that you work on is that I mentioned this low income adjustment from back in 2010. That was set up to make sure that somebody who was really working minimally and trying to make every nickel stretch as far as possible, that they were able to have some minimal subsistence. And how that was done was looking at just one parent's minimum wage. But the economists have said that really, now that we've had a chance to look at some things, that it's better to consider the minimum wage, the federal minimum wage of both parents in terms of setting the basic child support obligation and then dividing it. Pardon me. So if you look through the excuse me, as I just gave myself a paper cut. Did you ever notice how those sometimes hurt worse than other cuts? If you look through the material that I provided through the link that George Katanzari emailed out, you can see some illustrations in the 100 to 660 range of the basic child support obligation amount, how those are changing. And they are going down a little bit. And then you'll be able to see how those kind of phase out. So, that's kind of an interesting thing that will affect some worksheets that we prepare more often than not, probably from cases involving Title 4D establishment or modification. But the other thing we had to do was we had to adjust as I mentioned, we were kicking the 6% rule out, and you might remember that the idea there was that 6% of that combined child support obligation, if it was $100 a week, $6 that week was the uninsured healthcare expenses. Well, since we took out the 6% rule, we realized that we needed to adjust the support schedules so that we were getting something that was an actual child support, and we weren't kind of double dipping because we've got a new method for dealing with the uninsured expenses. If many of you have clients that will need to worry about this, I congratulate you. I don't think that I ever did, but the new schedule stopped at a weekly combined income of $9,190. So if there are people where their combined income ends up above that amount, and they are out there. A lot of them have some sort of a medical or orthodontics degree, but anything above 9,190 degrees is just going to be computed in as 8.1% of combined weekly income. So again, probably not something that's really going to affect a lot of us out there. I'm not going to see a lot of those, but we had some of that. Now, some of the changes have meant that, like where we have parents of one child, the lower weekly combined incomes in the $100 to $600 ranges, as I mentioned, the combined basic child support obligation, that number that goes into line 4 on the worksheet, is generally lower. And then as people have combined weekly incomes over $640, you'll see that the basic child support obligation is going to increase a bit. And some of these increases are only $2 or $3. I mean, we're not talking about major differences at the lower end as that sort of phases out. But one of the things I provided in the materials that you can download is one of the things I provided is the redlined support tables, where you'll be able to see there's the old number that's crossed out and here's the new number, and you'll be able to see where these things change. As a practical matter, it's it will make a difference, but there's nothing there that you need to memorize, certainly. Let's talk about the 6% rule and its demise. When the topic was first raised at a committee meeting, I think it took less than 4 seconds for one of the committee members to make a motion to get rid of the 6% rule. There's very little discussion, and the idea was approved unanimously. It used to be under the 6% rule that you had 6% of the basic child support obligation was earmarked, if you will, or identified as dealing with uninsured healthcare expenses, and the child support payor was prepaying his or her share. And then anything above that, of course, was paid in proportion to the party's incomes once the support recipient hit that certain threshold figure. And over the last 4 years, a lot of things came to light. And of course, even before that, things came to light. And there were just tons of problems with the 6% rule. For example, if the custodial parent didn't really have any uninsured medical expenses that they were paying out of pocket, that was, the 6% or the 3% or 2% of whatever, that percentage of the payor's weekly payment was kind of a bonus or a windfall to the other parent receiving the support. Now, might have only been $4 in a week, but for some families, $4 is a huge deal. We all know that figuring out what the bills were and keeping track of the payment of the bills by the support recipient and figuring out when they got to the 6% was a pain. All of us have seen cases where custodial parents would delay asking for reimbursement, or when the payor might come in and ask for a modification, all of a sudden there's either a motion to enforce or a rule to show cause for 2 years worth of uninsured expenses. It was just, it's one of those things that it seemed like a good idea at the time. Perhaps. One of the other things that we learned is that, especially with the 2013 and 2019 consumer spending surveys, the 6%, this idea that 6% of the money spent on the children went for this medical care that wasn't insured really turned out to be an erroneous conclusion by whichever economists came up with it. And I can't recall from Dr. Betson's lectures to us about whether, he did lecture to us for 4 hours in total. It was kind of like being a graduate student in an economics program. But it was also somewhat informative just conceptually, even though a lot of it was way over my head. But I can't remember whether the guy who came up with this 6% figure either retracted his statement before, or if others disproved it, whatever it was. It just turns out that not only were there some good practical reasons to get rid of this thing, but it turns out the 6% rule didn't have a very good foundation in economics. So what we've done is we've taken the healthcare expenses out of the basic support schedules. And we've had to, so I guess I need to update this. And we've had to revise the worksheet to take out that whole 6% calculation. Of course, that also meant we had to review and revise the parenting timetable, because part of that 6% thing was built in there for the parenting time credit. And thankfully, Dr. Betson is the one who could do that, because he had the mathematical formula and was just able to plug things into a spreadsheet. And I should mention that for anyone who may be wondering, is Dr. Betson really an expert in this field? He's been hired by a number of states around the country. Michigan and Georgia come to mind. So he is one of the people that is well known for this field. I also know that I met with a subcommittee of the Illinois group that's trying to do their revision to take effect, I think, in 2025, because they had some questions about what we were doing, and they were familiar with Dr. Betson and some of his things. So I was at least, I never had any questions in my mind. I figure he's a professor at Notre Dame in the economics department. He probably has some credentials to earn tenure there. But it's always nice to know that the expert that you picked is somebody that others rely on as well. So what have we done with healthcare expenses now? Well, we kind of, and this is all in the revised guideline 7. And basically this is it. The routine non-prescription stuff, like Tylenol, bandages, vitamins, things that aren't going to be sent back and forth from home to home with the child, are just, if dad is the non-custodial parent and he buys the vitamins, those vitamins will remain at his home, and he pays that expense. And what we're really talking about here is the stuff that could be submitted to insurance. In other words, not your, I need a box of Band-Aids, or I need, allergy medicine or something like that. What we're really talking about is things that could be submitted to health insurance if they have health insurance, like doctor visits, prescription medications, treatment plans for chronic diseases, ER visits, hospital stays, and the like. And basically what we're doing is we're making each parent be responsible for those expenses in proportion to their incomes. But part of what I think a lot of attorneys are going to like is that the documentation relating to the income and expenses that are paid or incurred parents have to send those to the other parent within 30 days of getting that documentation. Or then if they don't, courts have the discretion to say, well, you didn't get it done within 30 days. Therefore, you have waived your right to request reimbursement. It's our hope that this is going to prevent a lot of sandbagging that we see, or what looks like sandbagging. Part of what we also have the discretion to do, and certainly I would encourage it among practitioners, specify what expenses are covered by the term healthcare expenses, even down to orthodontic, vision, mental health care. Do you want to include chiropractic care? Alternative medicine, acupuncture, whatever. You can be as specific in there in the order as you want, and it's probably a good idea. I mean, I typically say medical, dental, optical. I've been trying to add orthodontic just to avoid that argument. Excuse me. Also, we have the discretion in looking at these expenses and these claims for reimbursement to decide, if someone chose to use an out-of-network provider, does that make it an unreasonable expense? And should we treat the expense as if it was an in-network provider and only require the other parent to put together that or to contribute only to that lower amount? So, there are some things there that you will want to review in Guideline 7 and the commentary. Hopefully it will make people's lives simpler. Whether experience will bear that out, I don't know. Oh yeah, I forgot to do this slide when I said that, this rule was gone. And I have not heard anybody complain about it yet, and I doubt that they will. There may be criticism of what we've put in place instead of the 6% rule, but I think people generally have been receptive and happy to see the 6% rule go. Kids who are exercising different numbers of overnights with the parents or the non-custodial parents. This comes up once in a while. And it's, if child 1 is spending 100 nights a year with dad, and child 2 is spending 80 nights a year with dad, and say child 3 is only spending 30 nights a year, in the past, I think everybody's just tried to figure out, okay, what's a compromise number of overnights that we can plug into the child support calculator, come up with something. And one thing that we know is there's an Indiana Court of Appeals decision, Blandford versus Blandford, so far as I know, not related to the Gregory Blandford that we all know. But the Blandford versus Blandford opinion says that courts can't simply average the number of overnights. I'm not sure, again, this is getting into some math and calculations here that I'm not entirely fluent in, but what Blandford versus Blandford said, you need to average the parenting time credit. So what does that mean? Well, when you fill out that parenting time worksheet, that's what you're doing. And so what you're going to end up doing is preparing a separate parenting time credit worksheet for each of the children, like one exercising 56 overnights, one exercising 120, one exercising 180. Each of those will produce a different parenting time credit amount. And then we average those and enter that average on the worksheet. Now, as you're sitting here thinking, oh my God, as soon as I see Wilson, I'm going to pummel him because I do not want to have to create 3 separate worksheets. Let me tell you that the good news is that the Indiana Online Child Support Calculator from the Supreme Court's website has been revised and will go live on January 1 or maybe January 2. But it will let you, as you're putting in child data, enter how many overnights that child is spending with the non-custodial parent. So it will produce all of the parenting time credit worksheets for you and average them. I really need to compliment the people at the Office of Court Services, the programmers there, because we asked them, can we do this? And they didn't even blink. They said, of course we can. We'll get it done. And they did it pretty quickly. Whether is it Support Master, the private software, what they're doing in terms of their software, I don't know. And when they'll have any revisions, I don't know. It's just not anything I've ever dealt with them in the past. But at least on the Supreme Court's end of things, they are trying to make attorneys and judges' lives a little easier. And I can't say that we never really realized how much we rely on the calculator until we try to do these things by hand, which we had to do in these cases since as we were doing some test runs and like creating scenarios for presentation to a judge's conference, and we had to create the answer. The calculator is something we probably take for granted. Another thing that we've done in the guidelines is we have emphasized that you've got to submit a child support worksheet. It's required by statute. Court of Appeals has told us many times. The the child support guidelines tell us you've got to have one in the file. And just do it, please. Because later on it will cause headaches for whoever may be in the position of trying to figure out how was some child support even calculated here. And we need to have those in the file. Just as you all know from your files, when you don't have a copy of that old worksheet, and if you can't get into it through Odyssey or my case, then it's just a headache. The other thing that we have clarified and emphasized in the new guidelines and commentary is that when parties are deviating from the recommended amount, up or down, maybe down to 0, the court has to make written findings that indicates that the application of the recommended figure would be unjust or inappropriate. So if we're doing something that's not the result of the guidelines, we've got to have something in writing that explains why we're doing it. And what we have done, while the guidelines in the past have offered a handful of possible examples, we have expanded that list. And the reason that this is necessary is, to comply with federal law, for one. But we have to remember that custodial parents do not have the right to waive child support on behalf of a child. They are really receiving these funds kind of as a trustee. And having that worksheet in the file with any explanations helps us understand when we are looking at modification in the future, whether it's appropriate. And the reasons for the deviation don't have to be overly complex, but simply saying that the parties agreed to a $0 support order is probably not enough. Parties agreed to a zero support order because A and B. And it might be something as simple as saying they have agreed to share all expenses in proportion to their incomes, or dad is going to pay expenses for X number of months and mom will pay for Y number of months. That's in proportion to their incomes. It doesn't have to be really difficult. We've always noted before that there's a downward deviation because the parent is going to incur substantial expense in exercising parenting time. That's there. So just remember to avoid having me or somebody else kick an agreed order back because it just says there's a $0. We need to know why beyond just because parties want to do it that way. All right. Split custody. For some reason, where you've got one parent with custody of one kid and another parent with custody of one or two kids. For some reason, people around the state felt that we needed a little more guidance on how to calculate support in that instance. I never felt that it was a problem locally. So maybe it was just a matter of local practice, but basically you're going to create a worksheet for each parent as if that child living with the parent is the only child, and what would the other parent pay in support. Do that again for the second parent and other kids, and then net out the difference. The commentary to the guideline 6 where this is addressed, basically I think what we've done is try to better explain the computation. I never thought that it was that difficult. I haven't run into any attorneys who ever seem to be puzzled by it, but at least it's there. So maybe the explanation will better help you explain to clients what's behind that. If you're doing paternity cases, House Enrolled Act 10009 amended Indiana Code 3114-701, which is going to be effective January 1. And this now says that the court shall order the father to pay at least 50% of the reasonable expenses of the mother's pregnancy and childbirth, including the cost of prenatal care, delivery, hospitalization, other necessary and reasonable expenses incurred in connection with the child's birth, postpartum expenses, and postnatal care. That's what the legislature has commanded courts to do. We have updated the child support guidelines to indicate that, because typically in an establishment of paternity, that establishment order contains all those things. My only complaint about this is the requirement that father pay at least 50%, because I can envision cases where mothers might earn 90% of the combined income. If it was up to me, I would have pushed the legislature to do it in proportion to parties' incomes. As some of you know, that's how I like to do a lot of different things when dividing up expenses. I just think it's the only fair thing to do. But the legislature has spoken, and it's judges will be able to, at least 50% means at least 50. If we've got something where the birth parent has significantly higher income, we can always decide that we're just going to limit it to 50 and not make it a higher percentage. I don't know if that was a bit of gender bias on the part of the legislature, that they assumed fathers would always be making more money. Certainly, we see cases where that is the situation. But in any event, just be aware that those will be issues in paternity cases starting next month. As I mentioned before, the child support calculator is going to be updated, and it will be available for use starting in January. I'm told January 1. I don't know who's going to flip the switch on New Year's Eve or on January 1st, but we'll find out. Certainly, it ought to be operational on January 2nd, which is perhaps the first time anyone will start doing that. And again, it will calculate the parenting time credit in that situation where you've got 2 or more kids who are spending different numbers of overnights with the non-custodial parent. One question that's come up a few times is whether these new guidelines are going to be sufficient grounds to, in and of themselves, a sufficient reason to seek modification. The answer is no. Indiana statute still requires either that you've got a 12-month or older order and a DBA or a difference in 20% or more, and B, the possibility that there's a major change in circumstances so that the old order is unreasonable, like somebody loses their job. Plus, even though some might want to seek modification to get rid of the 6% rule, there is a chance that a parent's support obligation will go up or down because of the revised economic data. So just be aware of that. But if you put together a final support order in a divorce last month and in January, your client wants to have you file a petition to modify just because we have new guidelines, that won't work. Let's see. Yeah, okay. I just covered that. Here are some of the guilty parties that were involved in this whole process. I really should compliment Judge Tom Hallett out of Lake County. He's been our chair for at least a couple of years, as long as I've been on the committee anyway, and really did a nice job of getting us through the process. As you can see, I am one of the guilty parties. I'm not trying to hide that. We also had the help not only of Professor Betson, as I said, but Jeff Berkovitz and Joe Fisher from Office of Court Services. Jill Russell from Indiana Office of Court Technology was our child support calculator guru in getting that changed. We had help from other people in Office of Court Services, the Child Support Bureau in the Department of in DCS. We had the help of people from IPAC, since they're involved with the Title 4D cases. So a lot of people involved here. And all I know is that I'm trying to count and see if I will be off the committee by the time that this has to be done again to become effective in 2028. And it's not that it's bad, but it is a lot of hard work, and that economics stuff gets a little over my head. Oh yeah, and I really do want to thank the more than 150 citizens and others who sent in some comments, even if they weren't helpful. I love to see citizens engaged with their government, even if they may be objectively goofy because they're talking about something that doesn't even apply. The fact that they're interested enough to sit down and fill out a form to send in a comment is important and heartwarming. I really appreciate the attorneys around the state who offered their comments. It was very helpful for us to have, somebody outside the echo chamber saying, wait a minute, that may not be a great idea, or saying, did you think of doing this? Here is the link that you can scribble down, bit.ly CS guidelines. I've been referring to the stuff that I put together that you can download. There's the link for that in case you misplaced George's email. If you still need it at some point, just email me or Amy McGuire. We'll get that to you. And again, I expect that come January 1 or 2, online, we'll have the updated documents without all the red line stuff. Are there any questions? Hearing none, wow, I guess I did a great job. Or everyone was asleep, which would be okay too.
I'll go ahead and send that document out to everybody, just so that you don't have to email us and ask. And I have a quick question. iPhone 80, is that you, George Horn? Maybe. He's the only one unaccounted for. Okay. If anyone missed the beginning because you had trouble signing in, I'm happy to send out the recording to you after the fact. Just email me. But I'll go ahead and send in full credit for everybody because I know you all were trying to get here. Any other substantive questions for Judge Wilson, or do we just want to thank him for coming? No? Anyone?
I think everyone wants to start their weekend early.
I know, or they have, and we just don't know, since other than Santa Claus there.
Yeah. They may have signed off, so, and that's all right. For those of you who are still around, just thank you. If nothing else, knowing that a few of you, or more than a few of you, were going to be here today, made me sit down and go through all of this stuff again, which helps me remember what's going on in these revisions. So I appreciate the opportunity to do that. And at some point, if you've got questions, don't hesitate to seek me out and ask. I'll probably tell you to go back and read the actual documents, because those are the things that actually, govern, as opposed to my interpretation. But all right.
The other thing too, when that does go live, let me know, Judge Wilson, and I'll go ahead and put that out in a newsletter, like as an email.
Okay.
Too, just so that we hope January 1st, like you said, but probably soon after that, if not.
Yeah, it should be January 1, or January 2.
Okay. I'm going to go ahead and stop the recording if anybody has anything else. If I can figure out why can't I find that button? Oh, there it is.